Good afternoon, one and all. Welcome to the Uttar Pradesh Assistant Prosecution Officer PYQs 2018 Round 2. चलिए तो पहला क्वेश्चन पढ़ते हैं. The court of session is established by, given the options, High Court, the state government, the central government, the governor of the state. So the correct option is actually B. Is the court of session is established by the state government. So state government usually establishes the session court, and it is being presided by the session judge, right? And the judge is being appointed by the High Court of every state. Moving on, second question पे चलते हैं. In respect of the cases instituted otherwise than on police report, under which of the following section charges are being framed? So the correct option is C. Section 246 of the CRPC is the section in which the cases are being instituted otherwise than on the police report, under which the charges can be framed. So our correct option is actually section C, 246 CRPC. Moving on, we have the third question. If a woman is sentenced to death is found to be pregnant, her sentence shall be commuted to imprisonment for life by the. So the correct option is C. It's the High Court. So usually section 416 of the CRPC says there is postponement of the capital punishment of the pregnant women, and if ever there is a sentence is actually basically commuted to the imprisonment. So the sentence is actually far more lesser as compared to the earlier, which is actually the main sentence. So the second sentence is commuted for imprisonment of life under section 416, and it is being done by the High Court. One of the most important principles of evidence law is that evidence to be weighted and not numbered is inherent in which of the following sections of the Indian Evidence Act 1872? So the correct answer is actually B, section 134. Now section 134 of the Indian Evidence Act says there is no particular number of witnesses shall be required to prove the facts of any case. Now even testimony of a single witness is sufficient for the courts to consider it worthy without corroboration. It depends upon the nature and circumstances of the case, and material evidence and number of witnesses has to be taken into account by the courts to ascertain the kinds of allegation which are being made. So the correct answer is B, section 134. Section 2 of the Indian Evidence Act 187 is actually it's a repealing act of 1938. So it's called the Repealing Act 1938. It's very much a direct question. Then we have match the list A with list B and choose the correct with the help of the codes given below. Now, answer number: facts which shows the preparation of section. Facts which shows the preparation. It's actually section 8. Facts which shows the preparation is section 8. Then facts which are being result of the fact in issue is actually section 7. Then facts which are part of the same transaction is section 6, and facts which are necessary to explain or is actually section 9. So the correct answer is A. Possession is the prima facie evidence of the ownership. This principle is basically described under section 1110 of the Indian Evidence Act. Now section possession is actually a prima facie evidence under section 1110 of the Act. Thus possession is being regarded as a right of ownership, and it gives the right to the rightful owner, to everyone except the rightful owner, and mere possession by the finder of the goods is sufficient to provide grounds for the action against one who deprives him of the object with no better right. So the one जिसके पास आता है, he assumes a better title than the rest of the people. Question number 8. Which of the following sections of the Indian Evidence Act provides provision for refreshing memory? Now, provision for refreshing memory are given under section 159 of the Indian Evidence Act. So, the correct option is A, section 159. And a witness under the examination may refresh his memory by writing made by himself at the time of transaction concerning which he is being questioned or soon afterwards. The court may consider it is likely that the transaction was at that time fresh in his memory. Question number 9. A spouse will be permitted to disclose the communication made during the marriage. So these are actually the communications which are actually which are actually given under the Indian Evidence Act. So under this, a spouse will be permitted to disclose the information during the marriage. So the correct option is with the consent of the person to whom it is made. So option A is actually correct. So spouse will be permitted to disclose the communication with the consent of the person to whom it is being made. Question number 10. Read the following statements carefully. The presumption of legitimacy of a child is governed by section 112 of the Indian Evidence Act. Narendranath Pahadi versus Ram Govind Pahadi is a leading case on the legitimacy of the child born during the continuance of a valid marriage. So the correct option is basically C. Both A and B are basically true. So the presumption of the legitimacy is governed under section 112 of the Indian Evidence Act. So the Indian Evidence Act 112 confers the presumption of legitimacy. So there's a period, actually there's a gestation period of 280 days. So that's being taken into account under section 112 of the Act. And when we talk about this case, Narendranath Pahadi versus Ram Govind Pahadi, it's the leading case on this particular proposition and this particular presumption. So both the A and R basically are true. Moving on. The burden of proof in a suit or proceeding lies on the person who either side on. This provision is contained in which section of the Indian Evidence Act? Now this provision is actually contained under section 102 of the Indian Evidence Act. So the burden of the proof in a suit basically lies on the other side. So the side which is actually asserting, so the burden of proof basically lies on that. And who would fail if no evidence were given on the either side. So if no evidence is being given, so definitely the version is on the other side. So the correct option is 102. Which of the following section of the Indian Evidence Act 1872 has been amended by the Criminal Law Amendment Act 2018? So under this, section 53A and 146 have been amended. According to the Indian Evidence Act, section 53A and 146 have been amended to make the provision in consonance with the other provisions of the Act. To make the provisions in consonance with the other Act. Not proved under the Indian Evidence Act means. Now, not proved according to means a fact is said to be not proved if it's neither proved nor disapproved. So option C is correct. It's neither proved nor disapproved. So the correct answer for question number 13 is C. Which of the following is not correctly matched? Presumption as to documents 30 years old in section 108 of the Indian Evidence Act. Burden of proving that person is alive who has not been heard for 7 years. Section 108 of the Indian Evidence Act. Dumb witness. Section 119 of the Indian Evidence Act. Presumption as to dowry debt. Section 113 of the Indian Evidence Act. Now section 113B talks about dowry debt of the 1872. And if a woman dies in relation with any demand for dowry and soon before death she has been subjected to any sort of cruelty or harassment, then the court will presume that that person who has actually given her the cruelty or who has actually caused the mental agony and pain is responsible for the death of the particular woman. So in this, option D is correct. Option D is wrong actually. So it's not correctly marked. It should be 113B. Under Indian Evidence Act 1872, facts forming part of the res gestae principle. Under Section 6 of the Indian Evidence Act, the principle of res gestae is actually followed, and hearsay evidence is not admissible in the court of law. Now, res gestae is actually the facts which actually form the part of the same transaction. So it is pertinent to basically examine when does the transaction start and when it ends. So the principle of forming part of the same transaction under 6 of the Indian Evidence Act. So option C is correct. The case of Palvinder Kaur versus State of Punjab relates to which of the following? Correct option is B. The case of Palvinder Kaur versus State of Punjab relates to confession. Which of the following section of the Indian Penal Code 1860 is related to Hicklin test? Now, Hicklin test is actually related to something which is not something which is obscene. So the court has used the Hicklin test whether the impugned matter tends to deprave and corrupt those whose minds are open. So something which is actually immorally influencing a person, and the test was found not to. Now this actually test does not violate Article 19 of the Indian Constitution, and this basically obscene act are coming under Section 292 of the Indian Penal Code. So Section 292 is actually the correct option. So the Hicklin test is basically related to something which is obscene. So obscene basically is covered under Article Section 292 of the Indian Penal Code. Now, disclosure of the identity of the victim of the rape is punishable under Section 228A of the Indian Penal Code 1860. Now, according to 228 of the IPC, whoever prints or basically punishes anything and against a person, then Section 376, 376A, B, C, D is found to have been committed, he or she he will be punished. So the person will be punished. So here, when because disclosure of an identity of the victim of a rape is not something which is being done, and it should not be done. So disclosure is something which is not being permissible under the law, and if ever it's being done, so definitely it's punishable offense under 228 of the IPC. A distinction has been explained by the Supreme Court in Nanak Chand versus State of Punjab relating to which of the following sections of the Indian Penal Code. So there's a distinction between section 34 and section 149. So this case is basically related to option D, section 34 and section 149. Now section 34 it talks about common intention and section 149 talks about common object. And section 34, an act must be done by several persons in furtherance of a common intention. Whereas under section 149, the membership of an unlawful assembly is itself an offense. So any member of which of any member of that basically community or unlawful assembly which commits an offense, basically he attracts a provision of article section 149. So 34 does not create a substantive offense or maybe a specific offense, and it just creates a joint liability. On the contrary, 149 basically creates a specific offense because being a member of unlawful assembly it's itself an offense. So this is the explanation being given for the question number 20. Then Criminal Law Amendment Act 2018 is being enforced on April 21, 2018. So this is the day on which there was an amendment to the criminal laws, and 2018 they were being enforced right from 21st April 2018. Now, which of the following is not a correct match? Extortion, dacoity, robbery, and theft. So we have certain sections of the Indian Penal Code being written against them. So the correct option for question number 22 is C, robbery. So we have extortion under 383, that's correct option. Dacoity is under 391, correct. Then robbery is actually 390. Section for robbery is 390. Then we have theft. Theft is actually 378. So the Option which is not correct is actually robbery. A cut down a tree on Z's ground without his permission and takes it away without Z's knowledge. So, what is it among these particular options? So the correct option is A. It is a theft because A has actually severed a tree from his ground. So there's a usually when we talk about theft, usually there is a dishonest intention, and if the intention is actually dishonest and there is actually taking away of the movable property. So here there is a dishonest intention on part of A because he has actually severed a tree from Z's ground and without his permission. That means intentionally he has done and he hasn't taken. Whenever we are talking about theft, so the permission is not taken. There is a dishonest intention and there is taking away of the movable property. So here the tree is being taken without knowledge, so it is a theft. So option A is basically correct. Question 24. A meets a bullock cart carrying a box of treasure. He drives the bullock in certain direction in order that he may dishonestly take the treasure. A has committed the offense of. So usually A has committed theft. So A meets a bullock carrying a box of treasure. Now he drives the block. So there's this word is being used dishonestly, right? So the word dishonestly is used. So when we talk about dishonesty, it talks about theft. So here theft is being talked about. So option 3 is being correct. So theft is the one. So A has committed the offense of theft. Now making preparation to commit dacoity is punishable under which section of the 1860 Act? Now making preparation is actually punishable under section 399. Under section 399 of the IPC, making preparation to commit dacoity is punishable. Now, with a rigorous imprisonment, there is a punishment for this. There's a rigorous imprisonment of about 10 years, and that person will also be liable for the fine. Now, there are certain list of decided cases, and there are sections related to the Indian Penal Code. So, we'll have to match the following. So, Barinder Kumar Ghosh is related to section 34, that's common intention. Then Maharashtra KM Nanavati was a state of KM Nanavati was a state of Maharashtra. So there is a distinguishment between. So it tells about section 300. It talks about murder. Then we have Mithu versus state of Punjab. That's section 303. And R versus Govind is actually distinguishing between section 299. That is culpable homicide and culpable homicide not amounting to murder. So this is 299 and 300. So these are. So the correct option for question number 26 is A. So I've actually matched the following. The section list 1 is actually matched with list 2. Now, which of the following sections of the Indian Penal Code, kidnapping or maiming a minor for the purpose of begging, has been discussed? So, kidnapping can be from lawful guardianship, kidnapping can be from India, and kidnapping can be from the lawful guardianship. So here, if a child or if a minor is basically kidnapped for the purpose of begging, so section 363A is being attracted. So it's an offense under section 363A of the IPC, and whoever kidnaps the person or whoever keeps that minor in confinement will have a rigorous imprisonment, terming a jail, attracting a jail term of about 10 years with a fine also. So the person would be liable for fine and would be imprisonment also, would have an imprisonment of about 10 years. Now, the word valuable security is defined in the Indian Penal Code. Now, valuable security is something which is a document through which any legal right is basically created, extinguished, or maybe extended, and which creates a certain legal right. So, that is something which is called a valuable security. And the correct option is actually section 30. So section 30 of the IPC basically talks about the valuable security. A causes Z to go within a walled space and locks Z in A. A shall be guilty of. A shall be guilty of wrongful confinement. According to section 340 of the IPC, wrongful confinement is basically defined under section 340 of the IPC, that whoever wrongfully restrains a person in such a manner so as to prevent the person from proceeding beyond certain limits. So that's called to wrongfully confine a person. So under this, section 340 is being practiced. So the correct option is B, wrongful confinement. List 1 with list 2 has to be matched. Section 81. Section 81 talks about Section 81 talks about defense of necessity. 84 talks about act of the person of unsound mind. Then section 86 talks about intoxication. And 95 talks about act of causing slight harm. That's called for trivial things. Section 95 is being attracted. Question number 31. Use of violence by a member of an assembly of 5 or more person in furtherance of a common object will constitute. It will constitute Roy. So under 146 of the IPC, we have a member of an assembly of 5 or more in furtherance of a common object, so it will be called Roy. A intentionally causes Z's death partly by illegally omitting to give Z food and partly by beating Z. A has committed the offense of. So here A has committed the offense of murder. So option 3 is basically correct. So section 3 is murder, except in the cases culpable homicide is murder in which there is intention of causing death. Now that intention should be there in such a manner that there's a bodily injury and there should be an evidence in the sufficient which is ordinary and sufficient in the course of time, and definitely that death or that injury basically results in the death of that particular person. So these are the 4 ingredients when we talk about murder. Then we have Mehboob Shah versus King Emperor. Now this is basically a leading case on common intention. So common intention is actually indicated under section 34 of the IPC. So when a criminal act is basically done by several persons in furtherance of a common intention, then each of the person is basically liable for that act as if that act was basically committed by that single person. So here section 34 is being attracted and the correct answer is D, common intention. Now, which section of the Police Act 18? Now, this is a question from the Local Police and Regulation Act of UP. So, which section of the Police Act 1861 provides duties of the police officers? So, duty of the police officers is given under section 23 of the Police Act 1861, and it shall be the duty of every police officer to obey and execute the orders and warrants of the court, which are being issued to him by any competent authority, to detect and bring the offenders to justice. Now, which of the following section of the Police Act 1861 empowers the police to regulate the public assemblies and processions and licensing the same? So, the correct answer is actually B, section 30. Section 30 of the Police Act, it empowers the police to regulate the public assemblies and processions and licensing the same. Thank you.